One unique feature that the majority of criminal justice associations share is that they are typically public organizations. And, according to Michael Lipsky, those who work in criminal justice agencies are street-level bureaucrats who often have an enormous discretion, and they routinely have to make personal choices as they struggle to serve too many clients with not enough resources. One aspect of criminal justice agencies is that, unlike other public organizations, the clients often tend to be there against their will. Whether it be a juvenile probation officer, a public defender, or a correctional counselor, almost always justice employees work with individuals who have broken the law. All too often, the clients of criminal justice agencies tend to be from the wrong side of the tracks. Also, they tend to be disproportionately young, male, and often members of racial minorities. Given this, we should expect to see organizational behaviors which are unique to criminal justice agencies, and we often do. Take, for example, the courtroom work group. Even though one might think that a public defense attorney would have an adversarial relationship with the prosecutor, this is clearly not the case. The fact is that both the defense attorney and district attorney have similar backgrounds and tastes. They work together to complete their duties as they process clients through the criminal justice assembly line. As Michael Lipsky would argue, each actor in a courtroom work group is a street-level bureaucrat who possesses discretion to make important decisions, yet realizes the utility of engaging in informal arrangements that are outside of the official court bureaucracy. In his classic work titled Bureaucracy, the renowned German sociologist Max Weber argues that managers must adhere to a formal bureaucracy in order to effectively manage their subordinates. Weber contends that bureaucracies must be first and foremost characterized by a formal hierarchical structure where every level controls the level below and is also controlled by the level above. In law enforcement agencies, this aspect of Weber's theory is often carried out to a T, as most of these organizations are organized along quasi-military lines. For example, in a typical police agency, a sergeant is often the immediate superior to regular patrol officers. He or she, in turn, is the subordinate to a police lieutenant, and the chain of command goes all the way to the top, ultimately reaching the chief or assistant chief of police. Another aspect of Weber's work which pertains to bureaucracy focuses on the importance of written rules. These allow for a certain degree of consistency within the organization. Next, Weber contends that the most efficient bureaucracies are purposely impersonal. While some have criticized this aspect of organizations, Weber argues that a certain level of detachment permits both employees and clients to be treated equally. Also, according to Weber, employees within organizations must be selected based upon merit and technical qualifications. He also asserts that these individuals must be free from arbitrarily being dismissed. In the United States, governmental employees are typically protected from civil service boards, collective bargaining agreements, agency policy, or at the very least, state and federal civil rights legislation which precludes dismissal based upon race, gender, or military status. Even in states such as Texas, where at-will employment is prevalent, today there are nevertheless many more protections for public employees than in the past. Prior to the Pendleton Act, not to mention a plethora of other federal laws and court decisions leading up to the present day, both state and local employees were typically beholden to a politically elected or appointed person. Public service today is neutrally competent, meaning that it is politically neutral and it's focused on the skills and abilities of workers to do the job at hand rather than being beholden to political alliances. So in essence, getting a job in public service was more based upon who you knew rather than what you knew. Obviously, this type of model was not conducive to public service, as it flies against Weber's notion of what an efficient bureaucracy should look like. If one truly reads the original work of Max Weber, it might seem at first glance that he overemphasizes the importance of rules and regulations. After all, rules, in and of themselves, do not uniformly produce the same expected results. For example, let us consider the Transportation Security Authority, or the TSA, which is a federal agency responsible for maintaining the security of our nation's airports. Have you ever traveled from one city to another and been treated graciously and with the utmost respect, only to be treated in an entirely different manner by the same organization in another city? If so, this begs the question of why is there such an enormous variance of different branches of the same organization with the same system of rules and regulations? Why are there such different work environments, both for the consumer as well as the individuals who are employed within the governmental organization? One of the answers to this question is that management practices make all the difference. This course is intended to provide graduate students and perhaps future or even current management of criminal justice personnel with insights into various theories of management and supervision, while also focusing on everyday operational and legal realities of justice administration. There is no question that managers of criminal justice personnel face unique challenges that are not shared with corporate executives in the private sector. Unlike Fortune 500 companies, which are typically beholden to stockholders in the free market, criminal justice agencies tend to have characteristics which are associated more with closed organizations. A closed organization tends not to be as easily influenced by its immediate environment. Today, with the intervention of the court, as well as policies created to ensure accountability, such as the Freedom of Information Act, there are no criminal justice organizations which are truly closed. Nevertheless, the criminal justice organization is more closed than other types of organizations. Prisons located in rural areas are most likely the best example of closed institutions. But again, this term is relative. It is probably fair to say that criminal justice organizations are more open today than they were in the past. But nevertheless, due to the nature of the job, there may be a certain aspect of secrecy inherent within justice occupations. This indeed presents a legitimate concern for the management of criminal justice personnel, and if left unchecked could lend itself to on-the-job deviance, or what Crank and Caldera refer to as noble cause corruption, where justice employees intentionally disregard policies or even break the law themselves in an attempt to make the world a safer place. The consequences of noble cause corruption are enormous. Yet this is a very real phenomenon, especially in the realm of policing, where officers may have a tremendous amount of discretion. Managers of criminal justice personnel must be cognizant of the fact that staff and even other administrators will be exposed to temptations to violate rules, procedures, laws, or standards of ethics. Also, virtually all criminal justice occupations tend to be male-dominated, with perhaps the exception of probation. It is not at all uncommon for criminal justice workplaces to have incidents of sexual harassment, of both the quid pro quo and hostile work environment variety. If, as a current or future manager of criminal justice personnel, you ever have a victim of sexual harassment come to you as a complainant, this must be treated with the utmost sensitivity. Also, before conducting an official investigation, it would be beneficial to request the victim to write an official statement detailing the alleged harassment. And remember that even if an employee is identified as harassing someone else, he or she has rights too. While it always behooves an administrator to thoroughly investigate a complaint, a prudent manager must nevertheless be cognizant of the fact that a careless, sloppy, or haphazard investigation could possibly result in a defamation suit by the alleged harasser. This illustrates that a manager of criminal justice personnel must be respectful and civil in his or her interactions with everyone. Due process protections and considerations must be given to staff as well as the clientele in order to ensure optimal program delivery. This means that both supervisors and subordinates should base their behaviors on a deontological ethical system. Managers of criminal justice personnel who operate under a deontological ethical system are concerned with how a goal is achieved. In other words, these actors are especially sensitive to the means and firmly believe that the end never justifies the means. This is often a challenge, especially when we consider that justice employees often have little control over the clients that they must deal with on a day-to-day basis. Consider, for example, the correctional officer who works with super seg inmates on a daily basis. If this officer is not rotated to less stressful assignments and instead remains stagnant in what many would consider to be a very toxic environment, this may very well result in unprofessional behaviors of an egoistic nature. Clearly, one of the many responsibilities of the justice administrator is to frequently check the pulse of the agency he or she has formal control of. Throughout the semester, we will examine the various roles and responsibilities of justice administrators as they struggle to achieve justice for all.